Thank you. Welcome members to the 8th meeting in 2014 of the Delegated Powers and Law Reform Committee, and ask members to switch off mobile phones, please. Agenda item 1 is a decision on taking business in private. It's proposed the committee takes items 5 and 6 in private. Item 5 is consideration of a draft of the committee's 3rd quarterly report, and item 6 is consideration of our approach to the draft Agricultural Holdings Scotland Act 2003 Remedial Order 2013. Does the committee agree to take items 5 and 6 in private, please?
Agreed.
Thank you. And item 2, instruments subject to affirmative procedure. No points have been raised by our legal advisers on the Local Government Finance Scotland Amendment Order 2014 draft, nor on the Social Care Self-Directed Support Scotland Act 2013 Consequential and Saving Provisions Order 2014 draft. With regard to the latter instrument, the committee may wish to note that the Scottish Government has offered to correct errors in the preamble in a final version of the order to be laid once the substance of the instrument is approved by the Parliament under the affirmative procedure. Are members content with those instruments, please?
Content.
Thank you. Agenda item 3 is instruments subject to negative procedure. The Council Tax Reduction Scotland Amendment Regulations 2014, SSI 2014-35. Our legal advisers have suggested that the regulations raise a question of whether they relate to matters which are reserved by Section F1 of Part 2 of Schedule 5 of the Scotland Act 1998, and as such the committee may wish to report the regulations as raising a devolution issue. The matter was also raised in connection with the Council Tax Reduction Scotland Regulations 2012, SSI 2012-303, and the Council Tax Reduction State Pension Credit Scotland Regulations 2012, SSI 2012-319, which I refer to as the principal regulations. The Scottish Government's view is that the principal regulations do not relate to any of the reserved matters described in Section F1 of Part 2 of Schedule 5 to the Scotland Act 1998, and therefore no devolution issue is raised. I wonder whether members have any comments. Stuart.
Thank you very much, Convener. This is an order which causes charges to be reduced to certain categories of people. This is something with which we're extremely familiar and has never been subject to suggestion that it was a tax, because the provision in Schedule 5 heading to the Scotland Act heading F is that it relates to taxation. If we were to agree that this is indeed potentially virus, then we will, of course, by reading across, we would have to do so in relation to single occupancy, where there's a reduction in council tax, and many other things as well. Therefore, I would propose, Convener, that in line with our previous practice, that we do not refer this to Parliament.
Yeah. John?
Thank you, Convener. I believe that the advice that we've been given by our legal advisers is indeed the correct advice, that this does indeed raise a devolution issue, and that there is doubt that the regulations are within virus, as they may relate to matters which are reserved by Section F1 of Part 2 of Schedule 5 to the Scotland Act 1998, and therefore I want to see this objection upheld.
Okay. Richard?
I also support the recommendation that we draw the matter to the attention of Parliament, but wish to confirm, Convener, that that is simply the sum total of what we are seeking to do, is to draw the attention of Parliament to the legal advice this committee has received.
Anybody else want to comment? This is familiar territory, as Stuart Stevenson has indicated. Right. Well, if I heard Stuart right, I think the proposition is that these are intra-various and that we don't follow our legal advisor's advice. So unless anybody has anything else to say, I think we simply vote on it as we have before, and will therefore invite those who are in favour of the motion, which is that these are intra-various, to indicate now, please. And I think our clerks know that. And those who are against? And thank you. And there are no abstentions. So, as members will be aware, by 4 to 3 we have consistently agreed that this is intra-various and we will not report it. Thank you very much. However, it is on the record, of course. If I may move on, no points have been raised by our legal advisers on the Non-Domestic Rating Unoccupied Property Scotland Amendment Regulations 2014, SSI 2014-31, nor on the Council Tax Discounts Scotland Amendment Order 2014, SSI 2014-37, nor on the National Assistance Assessment of Resources Amendment Scotland Regulations 2014, SSI 2014-38. The latter instrument amends the National Assistance Assessment of Resources Regulations 1992. The regulations have now been amended more than 15 times. The Government gave a commitment to update the Committee on its plans for consolidation of the 1992 regulations last year, after the Committee wrote to the Government on the issue following its consideration of the National Assistance Assessment of Resources Amendment Scotland Regulations 2013. In response to a query from our legal advisers in regard to this commitment, the Government has explained its intention to consolidate the 1992 regulations by 2017, following a spending review in 2016 and in line with any legislative changes required as a result of the residential task force set up by Scottish Ministers and COSLA to review the shape and design of the provision of residential care. The Committee may wish to consider whether it is satisfied with this response and whether it wishes to pursue this matter further through written correspondence with the Scottish Government. Does the Committee have any views on this, please? No? Does the Committee agree to write to the Scottish Government again regarding this matter on the basis that the explanation is hardly 100% satisfactory?
Agreed.
Thank you. Is the Committee otherwise content with these instruments, please?
Content.
Thank you. No points have been raised by our legal advisers on the Home Energy Assistance Scheme Scotland Amendment Regulations 2014, SSI 2014-40. Nor on the Land Registration, etc. Scotland Act 2012, Commencement Number 2 and Transitional Provisions Order 2014, SSI 2014-41, nor on the HIV Testing Kits and Services Revocation Scotland Regulations 2014, SSI 2014-42. Is the Committee content with these instruments, please?
Content.
Thank you. Brings us to agenda item 4, which is the Tribunals Scotland Bill. This item of business is consideration of the delegated powers provisions in this bill after stage 2. Members will have noted that the Scottish Government has provided a supplementary delegated powers memorandum and will have seen the briefing paper. Stage 3 consideration of the bill is due to take place on Tuesday the 11th of March. The deadline for lodging amendments is 4:30 on this Wednesday the 5th of March. The Committee may therefore wish to agree its conclusions today. The power in new section 61A1 allows the Scottish Ministers to create offences and penalties in connection with proceedings before the Scottish tribunals. Provision may be made making it an offence to give a full statement, an application in a case, to fail to attend, or to give evidence before a tribunal, or to alter, conceal or destroy or fail to produce something that is required to be produced in tribunal proceedings in accordance with tribunal rules. The power does not specify any maximum as regards the penalties which ministers may impose when exercising their power to create offences of this kind. The Supplementary Delegated Powers Memorandum provides no explanation as to why ministers require the power to set the maximum penalty rather than have that specified on the face of the bill. Previously, the Committee has taken a strong line on the conferral on ministers of power to set penalties for offences. The Committee has taken the view that it is for Parliament to determine the maximum penalty should be, and that this is not a matter which should be delegated to ministers. Given the limited time, the legal advisers contacted the Scottish Government to remind them of the Committee's view that maximum penalties should be set by Parliament, and to ask for an explanation as to why an unlimited power was being sought. In response to this query, the Government has agreed to bring forward an amendment at stage 3, which will clearly set out in the bill the maximum penalties that can be imposed. Proposed maxima are, on summary conviction, imprisonment up to 12 months or a fine not exceeding the statutory maximum or both, and on conviction on indictment, imprisonment for a term not exceeding 2 years or a fine or both. Do members have any comments to make at this stage? Please, John.
Only to say that I would welcome, or I do welcome, the fact that the Government are proposing to bring forward an amendment at stage 3 to address this matter that we have drawn to their attention.
Okay. Any further comments? Does the committee therefore agree to welcome the Scottish Government's commitment to bring forward an amendment at stage 3, which will set the maximum penalty which may be imposed in relation to offences created by section 61A of the bill? We do. Okay, thank you. Section 71 has been amended at stage 2 to deal with concerns raised by the Justice Committee regarding consultation on instruments which impose fees and charges in new situations. Specifically, the Justice Committee considered that the consultation requirement should be mandatory and that users and stakeholders of the tribunal concerned should be consulted. The amendment made at stage 2 is more limited than this in 2 respects. First, the duty to consult only exists to the extent that ministers consider it appropriate. And second, the persons who have to be consulted are persons having an interest in the operation and business of the Scottish tribunals. This may not necessarily include individual users of a particular tribunal. Again, do members have any comments to make on this? Does the committee agree to draw the power in section 71 to the attention of the Parliament? And does the committee agree to report that it's content with the other provisions in the bill which have been amended at stage 2 to insert or substantially alter provisions conferring powers to make subordinate legislation?
Agreed.
We do. Thank you very much. That concludes the public part of the meeting, and I move the meeting into private.